IPR protection played an important role. IPR do not apply to the physical object in which the creation may be embodied, but instead it is on a intellectual creation that gets into picture and which requires a protection. So IPR became one of the important asset for the country to give expression to the moral and economic rights of the creator and public in access to this creation. IPR was given by the countries, and also it started government started promoting it, creativity and dissemination and application of the result to encourage fair trading. Then IPR contribute definitely to the economic growth of the country, and several the agreements included multilateral trading negotiations under Uruguay round. So innovating firms across worldwide became predominant in this. IP assets used in the business transaction had online exchanges. Buyers, sellers of intellectual property manage IP assets like stocks. So leading international instruments showed concerns in the IPR. So a system of accumulated practices rather than a set of fixed rules came into picture. International relations to protect the innovations came into world. The country is not a party to any international treaty on the subject. It like a number of international treaties and conventions were administered by WIPO, which deal with various aspects of IPR. So WIPO is nothing but World Intellectual Property Organization. It came into convention in the year 1967, and the need for international protection of IP arose when foreign exhibitors refused to attend the international exhibitions on invention. So the Paris Convention was held in the year 1883 to protect the trade marks, and the copyright also entered international arena during 1886 with the Berne Convention, where in 1996 it moved to Geneva to be closer to the United Nations and other international organizations. So WIPO is entering into cooperation agreement with the World Trade Organization, and also it enabled cooperation with the implementation of TRIPS agreement, and WIPO seeks to harmonize at national level the procedures, exchange of IP information, legal and technical assistance to developing countries, facilitate the resolution of private IP disputes. So this moved from one stage to a Paris Convention in 1883, and provisions of convention was divided into three categories like national treatment, right of priority, and common rules. So in these categories, the convention started having having given prominence for each of the category to get importance in the areas of invention. So national treatment, each contracting state must grant the same protection to national of the other contracting states as it grants its own nationals, and nationals of non-contracting states are also entitled for national treatment under the convention. So this was what came into picture. Right of priority was something in case of patents, marks, and industrial design. This got significance. On the basis of regular first application filed in one of the contracting states, the applicant may within a certain period of time apply for protection in any of other contracting states, and these later applications are regarded as if they have been filed on the same day of first application. So in other words, applications have priority over the applications which have been filed during the said period of time by other persons for the same invention. So utility model, marks, or industrial design. Common rules for patents are granted in different contracting states for same invention or independent of each other. Then contracting states does not oblige other contracting states to grant the patent. So patent cannot be refused or terminated in any contracting state. The inventor has the right to be named as such in the patent. He should be the important person who has to figure out. The grant of a patent may not be refused or invalidated on the ground that the sale of the patented product or of a product obtained by means of patented process is subject to restrictions or limitations resulting from domestic law. So patented product or a process has got its own value to play when during the research, if it is taken care of. Each contracting state takes legislative measures providing for the grant compulsory licenses, and patent may not be provided for except in cases where the grant of a compulsory license would not have been sufficient to prevent the abuse. So it is compulsory license based on a failure to work the patented invention only be granted to a pursuant as a filed one for 3 to 4 years. If the work has not been continued, then it will refuse the patentee to give any grant, or it can even with a legitimate reason the patentee can justify his inaction. Henceforth, the patent will get re-evaluated. So international intellectual property system has accumulated practices rather than set of fixed rules, and there are number of treaties, conventions on this. So WIPO has conventions at various stages and to improve the rules and regulations and the associated laws with it, in order to encourage states to sign its treaties and to enforce them. And widespread accession and consistent enforcement inspires the entire confidence that IPR will be respected around the world. So national treatment is each contracting state must grant the same protection to the nationals of other contracting state, and its grant is own nationals. So non-contracting states must be domiciled or have the real and effective industrial or commercial establishment contracting states. So this. With this, industrial designs, trade names, indications of a source, unfair competition. Industrial designs have to be protected because they incorporating the design or not. If that is, it could be incorporated easily into into the manufacturing sector of various organizations. Hence, that definitely requires protection. Trade names are in the contracting stage without the obligation of filing or registration should be protected. Indication of sources which are contracting state against direct or indirect use of false indication of the source of goods or identity of the producer, manufacturer or the trader. Unfair competition where each contracting state must provide for effective protection. So this is what is important in knowing about trademarks, uh, industrial designs, geographical indications, etc. Thank you.